All right, everybody, I'm gonna start. I'm Kristy Gouldsmith. I'm a data protection partner with Spencer West. With me is Brett Shaw, who does all of my marketing for me. Brett's going to be manning the chat because the way the presentation is showing on my screen, I actually can't see the chat. So we'll leave. So if you have any questions going through, put those into the chat, and then I'll deal with any questions at the end. Just because I can't see it. But Brett is there manning the chat. Um, Brett will also handle any kind of technical difficulties that you may have, or any kind of other stuff. He's my wingman on this for today. So welcome everyone. This is a webinar on data protection risks, opportunities, and compliance in dealing with AI in law firms. So the presentation is being recorded. Its legal basis is legitimate interest because the data of people would be if you ask a question or in the chat, it'll show up your name or whatever question you ask. So please be aware of that. The presentation will be shared with everybody who's on the webinar at the minute and those who can't make it, but who have requested that the recording be sent to them. So please be aware of that. If there's something you want to ask me later, then go ahead and do that. Just a bit about me. So I'm a data protection law specialist. I've been doing this since, oh God, it's been like 10 years now. This is my sole area of practice. So all I do is data protection stuff all day, every day. I work with clients across all sectors. I'm not sector specific. I'm also along with doing client work, I'm the Global Data Protection Officer for Spencer West. So I have a lot of insight in working with law firms and within a law firm. My contact details are on this screen, as well as my mobile number. So if there's something that comes up and you think, oh, once you've got the presentation, oh, I'd like to go and ask her that. That's fine. Just, ping me off an email or give me a call and we can go through whatever you have to ask. So we are looking at AI today, right? We're going to be looking at adoption, confidentiality, privilege, GDPR, and other bits and pieces. By way of additional background, I sit on the risk committee at Spencer West, and I'm also on the AI committee. So we've developed an AI policy, and we have a committee that assesses new AI platforms. Because obviously Spencer West is a consultant model law firm, so we have partners around the world who want to use different platforms. And part of the work of the AI committee is assessing whether we're going to say yes to that platform or whether we're going to say no to that platform. So why does it matter? Why does AI matter? It's because it's no longer a theoretical issue. People are going to be using AI, whether they've told you or not. So the real thing that we need to look at is whether, is how it's being used. Is it visible? Is it governed? And is it safe? All right. So people are now using it. And what do they want to use it for? They want to have faster research, drafting, and triage of documents. So that's a pressure of efficiency. Solicitors are supposed to get things done quicker and faster than we ever did. The next one is, why does it matter? Is client expectations. I have found that clients are expecting lawyers to use AI to speed up the service, right? But then comes the issue is if the service is sped up, does the service then cost less, right? But there's also, along with looking at the platforms, there comes a pressure of risk, right? Which is why at Spencer West, we assess all of these platforms. So you have to look at confidentiality, any loss of privilege, how accurate is your system, and how accountable is your system. So don't think that AI use is not going on in your firm, because it could be going on under the radar and you don't know about it. So the outcomes. At the end of the webinar, I want everybody to be able to make a defensible decision, which is an assessment of an AI, be able to look at an AI platform, and your defensible decision is, this is why we've accepted it, and here's all the reasons, and or this is why we have declined it. Because if you decline someone's request to use an AI platform, then you have to be able to defend that decision as well. So the first step in looking at this is spotting the risks. All right. When does AI use personal data, confidential information, privilege, or is it a high risk type of processing? What kind of information is going in there? The next one is classifying the input. So this is looking at which tool you were going to use. Are you going to anonymize data, or is approval needed? Like, approval from our perspective would be sign off from the AI committee that we've said yes, or we've said no. The next step along the line is assessing the vendors. Not all vendors are created equal. So assessing the vendors is learning what are the right questions to ask the vendors. What kind of training goes into the model? What about the retention and the security? Transfers. Where is your vendor located? Where is their AI provider located? Because the vendor could be different than the actual provider of the AI model that's being used. And talking about that, that's the sub-processors. So what sub-processors are they using? What do those sub-processors actually do? Where are they? And then the final step is looking at putting in place the policies to control the AI usage. What kind of training are you going to give people on using your AI tools? And who's signing off the AI adoption? So this is the agenda. We're going to look at AI use cases in a legal practice. We're going to cover confidentiality, privilege, and data classification. We're going to look at the UK GDPR and other data protection duties. I'm going to cover vendor due diligence and contracts, and then we're going to go through governance policies and implementation. So AI is already in law firms. All right, loads of law firms are using AI, but where you have to start is with the use case, not the brand name of the tool. Don't let the name of the tool, like Harvey or Lagora, drive the use case. All right. So the use case is looking at what do your staff or partners or fee earners want to use the tool for? Is it straight research? Are they looking for cases, or are they looking for statutes? Is it just a knowledge search, or is it a document review? Are they going to be uploading documents in, doing the extraction, any due diligence, doing disclosures? Or are they going to be using it for drafting? Are they going to be doing drafts, letters, bundles, whatever it is? Are they doing that? Or is the firm going to be using it for operations, any kind of client intake, conflict checking, billing, HR, training? So the use case will drive what tool you are going to assess. Don't just pick a tool that everybody else is using and think that it's going to be applicable to what you want to use it for. So when you're looking at the tool, it's the use case, and then is it receiving client matter data? Is it receiving personal data, privilege material, or any kind of confidential strategy material? So what do they want to do with the tool? That's your first step. Then there's the way we look at things at Spencer West and our AI committee is through this risk map. All right. And I've actually got this multiple page questionnaire that I have the person who wants the AI tool fill out along with the vendor. They'll need vendor input for it. So, but looking at it quite simply, it's the input. What are they going to be putting into it? You need to know that. The processing, what what entities are doing the processing, and where does the data go. You basically have to follow this along to go, this is what's going into the tool, this is where the information is going, including vendors and different countries. And the output is what is your partner, fee earner, going to do with that information? Is it straight research information where it's just pumped out some cases, pumped out some statutes, or have they actually put a scenario in there? You know, this is Mrs. McGinn's scenario, and it's come out with advice to be given to Mrs. McGinn's. And then you have to look at an important risk is the data that you are putting into this tool used to train or improve the tool? Okay, so if you can't answer those 4 questions in detail, then you don't understand the actual processing of that AI tool will be undertaking. All right, so this is a high level webinar. Like I say, these are the 4 kind of headline things, but we use a really detailed questionnaire that I've developed for going through an AI triage. All right, and I don't even look at one of these platforms unless the person who wants it, the partner, has filled out that form adequately. And it's not just like a no, yes, no, yes. I've had those. No, it's like putting in the information. So data categories. Now, data categories are really important because the tool that you're going to be using should follow how you've classified the data that's going into it. Okay, so we have public and open. This will be any sort of public law, published law, public guidance, general drafting. All right, this is the kind of search that you would pop into Google, right? You put in the case citation and then Google pops up with the case. That's the kind of thing that goes into a public open source AI. All right, the next category is internal type firm documents. Policies, know-how, templates approved. Because firms, there's kind of more uses for AI rather than just the partner. So the firm can develop a library of documents which are sorted by AI, and then the partner comes in and asks for these policies, templates. But those would be the firm's IP, and you don't want to go and pop those onto an open AI where they then wind up on the general internet. The next classification is client confidential information. This would be the client's identity, the facts of the client's matter, any commercial strategy that's being used with that client. Then you get even further along with privileged information. So any kind of solicitor-client communications or advice or litigation strategy. And then the next classification, which is also a red, is sensitive personal data. So any kind of health information, biometrics, anything to do with kids, or criminal offense data. So basically, my rule of thumb is that the more matter specific and sensitive the input, that's the data that's going into the AI tool, the stronger the approval, contract, and technical controls must be. So if the fee earner wants to have an AI tool where they're going to be putting in, I would say, client confidential privilege or any kind of sensitive personal data, any of that, then that sort of thing must be approved by our AI committee. And we look in detail at the tool. I assess the contract and the data processing agreement and look at who the sub-processors are and what those sub-processors are going to be doing, and the technical control. So that's all the IT security stuff, and our IT does that. But that's how we assess something. But these are the data classifications, which then, once you've classified the data, then you start looking at the tool that you want to use. You can't look at the tool and then the data for classification. The classification starts, and then you go and look at for the appropriate tool. So this is my practical rule set on what can and cannot be entered into AI. All right. I would advise you not to go no AI, right? Because people are going to be using it anyways. So it's not AI or no AI. It's looking at which tool, which data, which safeguards, and which approval are required. So the generally safer stuff is anything that you would have put into Google as a search. So if you're looking for law, looking for cases, is any kind of template that's people would want, or anything that's anonymized. Now, anonymized is actually very, very difficult, okay? Because that would be man in his 30s living in London. If you add in any other kind of detail, then it becomes the next bit, which is pseudonymized, where that person is potentially identifiable. So the safer stuff would be anything that you would actually have popped into Google to start with, which obviously would not be anything to do with clients or firm IP. The next bit that needs controls. Now, the needs controls section is where your AI committee has assessed that AI tool. All right, you know about it and you have approved it. That's the approved version. Now, on my last line, I have approved enterprise AI. All right. There's two types of subscriptions that people can get on an AI tool. There's going to be the consumer version and the enterprise version. You cannot use the consumer version. The consumer version does not come with a service agreement, and it does not come with a data processing agreement. You can't use an AI tool without a data processing agreement. So whoever wants this tool, like for us, for the consultant partners, they must buy the enterprise version, or we don't even consider it. I will never ever approve an AI tool on the consumer version because, you're running a business anyways, and you should not be using the consumer version. But the main reason is only the enterprise subscriptions get a data processing agreement, and that is critical. All right. So the next one is the absolute do not put any of this stuff into a public AI tool. And this would be, for example, Chat GPT, right? So we've said no to Chat GPT, Gemini, and Claude. Spencer West. So these things like client names, privileged communication, settlement strategy, witness evidence, special category, or criminal offense data. So when you're doing your AI policy, you need to tell people this kind of information. This is fine. This is the point at which we are going to need you to fill out the questionnaire, and we're going to assess the AI tool. And the other ones are an absolute no. And for the things that are the absolute no, don't enter into public AI. You need to have some kind of sanction or reprimand or outcome that will happen if somebody goes and does that. All right, so that's the stick at the end, and that would probably depend on whether they're an employee or whether they are a consultant solicitor. But make sure that you have some sort of outcome if they go and they do what you don't want them to do. Right. So I get a lot of questions when I'm dealing with law firms on confidentiality and privilege in the sector. So AI for firms isn't just a GDPR issue, right? It comes down to client trust, privilege, and a professional conduct, and it can be a problem. So you have to be aware of what the problems are. So we're looking at confidentiality. If you pop this information into your AI platform, are you disclosing the information outside of the circle of confidence? Legal privilege, legal professional privilege. Does the use of your AI tool undermine control over privileged material? And then client trust. Would the client expect this processing and understand the safeguards? All right. Clients generally would not expect you to be putting their matter information into an AI tool that is open or that uses their information to train the AI tool, the LLM at the end. They would not expect that. So when looking at these types of information, this is why you have an approved tool, right? So if the client questions, why are you using that? You can actually answer that question by saying it went to the AI committee. They filled out, there's a detailed questionnaire. We have assessed the tool on the basis of the questionnaire. We've asked the vendor questions. We have been through the service agreement, and we've been through the data processing agreement. You have to show that you've completed the due diligence on your tool. All right. So your tool will have confidentiality terms in its data processing agreement. In the agreements, there will be no model training. You need to have access controls on your tools. So that's who's using it and what are they using it for. For example, we've approved a tool dealing with US tax. And it is a research tool, but it's just popped up with this new AI feature, which will permit people to put client information in it and basically get an answer back. So we've limited the use of that tool. You cannot put client data in it. So that's the access controls, right? You need audit logs. Who's using it for what? Human supervision is very important because someone's got to look at the output, and clear messaging to clients about the AI tool. So looking at this, you get the client material, right? If it's a public AI upload, that leaves your firm's controlled environment. Then you run into the confidentiality issue where there's risk of disclosure and the fact that legal professional privilege may be waived. So legal professional privilege obviously protects confidential communications between the solicitor and their client. There isn't a lot of UK law on this. There was a recent case in the upper tribunal dealing with immigration, and the tribunal stated that uploading client material into an open source AI tool is akin to putting that information on the internet in the public domain, and thus breaches confidentiality and waives privilege. But the closed source AI tools, these are the ones you're going to assess, don't place the information in the public domain. They should keep it in your own bucket. So we have the rule at Spencer West that there is no client confidential or privileged material being put into public AI tools. Now, we're going to be putting a section in our engagement letter warning clients about doing that sort of thing. Because I had one of the partners phone me the other day. She does property, and she said, oh, the client has uploaded the entire lease with all the personal data in it into it was probably Chat GPT, and Chat GPT has come out with this information. AI has become the new asking, John down at the pub about your legal thing. So I have told her to go back and tell the client that doing that sort of thing breaches confidentiality and has the potential of waiving legal professional privilege as well. GR principles, GDPR through the AI lens. All right, GDPR sits and looks at AI. All right, AI does not sit in a silo on its own. So the GDPR principles of lawfulness, fairness, and transparency come into play here. Does your client, your data subject, or your staff member, or your candidate, do they understand what is happening? All right, not to the granular detail, because to be honest, most people won't get that, but they have to understand. We have the basic thing in the engagement letter about our use of AI. We use AI, something in blah, 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 that complies with all of our legal and data protection obligations. But we don't go into the nuts and bolts of what we're using, what it does, where it is, and all this sort of thing. And then we've got the news section about your use of AI, where we basically tell people, don't put this stuff into an AI tool. And if you've done it, go and tell us that you've done it already. Data minimization. Are you putting in only what the tool needs? Look at what the prompts are that are being used. If you don't need to put in Mrs. Miggins's personal data to get your research, then don't do that. Storage limitation. You have to look at not just the output, but the prompt that's used, because if it's a tool that people are using where client data is going in, then the prompt also contains the client data, not just the output. And the logs, like how long is that being retained for? And purpose limitation. Is the use of the AI compatible with the original purpose? Like if this was an engagement letter that was sent out ages ago and you're now using AI, is the client aware of that? And accuracy. This is really critical. Are the outputs checked before they affect any advice or any decision that's going to be made? Because we've all heard these cases, like the Pinsent Mason one, about hallucinations and inaccurate citations, cases, information. All right. And security and accountability. Can the firm evidence the controls that they have put on that AI tool? Have you done the due diligence? Do you have the policies? Have you trained people? Have you told them what they can do? Have you told them what they can't do? So AI works with GDPR. GDPR doesn't stop the use of AI, but it does control it. Now, when you're looking at your data processing agreements with your vendors, you have to look at who's the controller, who's the processor, or are they both? Now, don't just assume that the vendor is a processor. And you must read the actual data protection terms. That's the service agreement and the data protection agreement. Don't rely on the marketing speak from the vendors, because they tell you kind of what you want to hear, because obviously it's a sales pitch, right? It's not the legal bits, it's a sales pitch. So the firm is always the controller. Then you get the AI vendor. All right. They would generally be the processor, but you have to read the terms and see if they are using any information for development and improvement of the AI tool. And if they are, they must tell you. All right. Then you have to move down the chain and look at the sub-processors. Who's hosting the thing? Who does the analytics? Who's doing the support? And who runs the actual model? Because there are AI tools out there that I've assessed that are used. So it's the vendor, but then the model is going to be on OpenAI, Anthropic, any of those other, the AI models. But the vendor doesn't run the model. The model company is a sub-processor. All right. And you're going to be looking at what data is processed, for what purpose, and on whose instructions. All right. It's really critical that you have a jolly good read of the data processing agreement and ask questions of your vendor. So on the GDPR, we're going to be, the next thing you have to look at is what's your lawful basis? Are you being transparent? And really, what does the client expect? So you look at what's the processing. Is it prompts? Find me this, find me that. Is it document analysis, where someone's going to be uploading a whole bundle and they want an analysis of all of that 3,000 documents? Or is it producing a transcript? Is it a meeting tool that's recording the meeting and then popping out a transcript? What happens to the output? Like who's going to keep that? Where does that go? It should go on the client file, so that if your partner leaves or get hit by a bus, someone else can see what the output was. And is there kind of any automated triage? So the whole bundle goes in and it does, the AI does a good old sort, rank stuff. Okay. You have to know what the tool is actually going to do. And the lawful basis is going to be legitimate interest. You cannot make the use of AI a contractual term of your engagement letter. One, because it is not something that a client must agree, a individual client must agree to in order to obtain your services. So the engagement letter is what they get and what they pay. And you cannot contractually bind someone to you for you to use AI. And if it's an engagement letter with a corporate client, you cannot use contract either, because the contract between you and the company cannot bind their employees to be captured by AI. So it's legitimate interest. So who needs to be told about this? Whoever the data subjects are, it would be clients, potential clients, staff, and candidates. And then the big kicker is, what do you say in the privacy notice? It's clear enough to cover the material you use, but not going into the absolute nuts and bolts of how the system works or what systems you are using. So because you're going to be going under legitimate interest, you also have to do the legitimate interest assessment along with the data protection impact assessment for your high risk AI, which is the ones using personal data of clients or staff. So I've just mentioned DPIAs. DPIAs are a data protection impact assessment. And like I say, make them useful, not ornamental. So your DPIA is the bridge between the person going, we want this, and you going, now we can use it safely. So DPIAs are a long process. So I use the ICO's DPIA Word document, but it's not good enough for an AI tool. So along with that, I also use my detailed vendor questionnaire and partner questionnaire about how they're going to use it, who's going to use it, and for what sort of purposes. So when you're looking at, this is a high level diagram of a DPIA, you're looking at the tool, the use case, where the data goes, who it goes to, where, when, why, who are going to be the users, and what's the output going to be. You have to look at, is using this tool necessary? Is it proportional? Do you understand your lawful basis? And is it transparent? What are you going to tell people? You then look at the identifying risks to people. That's why it's a data protection impact assessment. What are the risks to the individuals, the clients, the staff? What's the risk to privilege and confidentiality? Oh no, it's an open source. Well, we're not going to use this now. And then the next step on a DPIA is looking at the risks. Well, this is what can seriously go wrong, right? You categorize the risks. And then you look at, well, how can we mitigate that? What kind of controls are we going to put in? Approvals. Well, we're not going to approve anything unless it goes through our long-winded assessment process. And then we have a meeting on it. Then we all look at it. We all discuss it. Then we decide what we're going to do. We look at the training of the AI tool. What contracts can we put in place to make sure that our data is segregated from everybody else's data? And what kind of security does the AI tool use? And then we make the decision. Then we do the sign off. We look at, can we live with the residual risk? And then we put a review date on it, because you don't sign this stuff off and just let it go. You have to keep going back with it, because I would reassess the AI tool probably about every 6 to 9 months, a year at the outset, because the way the technology is moving, it could be changing. As soon as you sign it off, it could be changing. So you need to keep an eye on it. So any kind of innovative tech, large scale sensitive data processing, monitoring, profiling, significant automated decisions, or any kind of vulnerable people, these are the keywords for the data protection impact assessments, but I would always do one on an AI tool. Right. You then have to look at special category and criminal offense data. All right, because these are the higher risk matters in a law firm. Employment will have health, disability, grievances. We're going to have clinical negligence, which already have medical records in it. Family is a minefield dealing with children, safeguarding, financial vulnerability, any sort of domestic abuse situation. For crime and investigations, obviously going to be criminal offense data, allegations. And then private client has got capacity, health, beneficiaries, any sort of family conflict. For these type of offenses, there has to be an absolute no to any kind of public AI, and you must put that in your policy. Because if you don't tell people, their response is to you going, oh my God, you put this in there and now this has happened. It's going to be, you didn't tell me not to use it. All right. So this type of information will only go into an approved AI tool with the DPIA, any kind of safeguards or guardrails that you want to put on it, and clear records, the due diligence records, the clear records of what you want people to do and what you don't want them to do. Then we've got international transfers and AI cloud chains. All right, you have to know where the information is going, right? Because you'll put it into the tool. You've got the service. Along with that comes the storage. Then there's sub-processors and the underlying AI model. You have to know where the country is that it's going to, how it's processed, how it's stored and accessed. You need to check the adequacy of the country, and then whether the international data transfer agreement is required, and you must do a transfer risk assessment, and you have to look at the sub-processor contracts. So due diligence, like we do a really complete due diligence process with our AI committee. We're looking at what's the use case, how is it using data, client data, what are the sub-processors doing with it, retentions, how long are the prompts, uploads, and things kept. The controller sets the retention period, so don't let the vendor fob you off with them setting their own retention periods. Look at the security, encryption, access controls. Is your data segregated? If it all goes pear-shaped, what's their incident response? And then controls. Can you tell the vendor, no training on the model, here's our retention periods, here's our access, and here's our sharing rules? And look at the concrete evidence that the vendor should be able to give to you, right? So you're doing the DPIA, but you can get security reports from the vendor. Are they ISO 27001 certified? Are they SOC 2? If they are SOC 2, then you want the latest SOC 2 report. You want to know who the sub-processors are, and you want their contractual terms with those sub-processors, especially the one that is the model. All right, so the procurement has to go through risk, IT, data protection, and everybody has to have looked at it, and everyone has to have signed it off. This AI is not just an IT issue. It's not just a data protection issue. It's looking at the risks, and if it all goes pear-shaped, how is it going to come back and bite us in the backside? Are we prepared for that? And can we deal with that? So looking at your vendor agreement, the contract has to match what you are promised. Don't just look at the marketing rubbish that comes with it, okay? You need to make sure there's no training on client data. All right, absolutely excluded. You look at who the sub-processors are and the transfers. You know, what do they say about changing sub-processors? Is it a general clause, or do you get to object? What's the objection route? What kind of security do they have? Do they have access controls, audit trails? You know, what's their notification process if there is a data breach? How are they managing the security? All right. And don't get fobbed off with stuff you don't understand. If you don't understand it, then ask. Because vendors tend to use a lot of techie terms. And sometimes, to be honest, you just don't know what those are. Look at the processor terms. Is there clear terms of the processors? Do you know who they are? What's in the contract? What does it say about confidentiality, assistance, deletion, audit, and breach? Does it conform with, at a minimum, and this is the minimum standard of Article 28 of the UK GDPR? That's the minimum. All right. And then you look at the retention and deletion. And this isn't just the kick out bit, the output. It's the prompt logs, the file deletion, and what happens at the end of the contract. All right. You need to read all these things. And then you have to assess that tool for your firm. What kind of support is there for any kind of privilege? Are your matters segregated? Will this tool fit your client commitments? And if the SRA or FCA or anybody else comes calling, can you answer their questions? Right. Looking at the outputs, we all know about hallucinations. Pinson Masons was a classic example of where it all went wrong. That's the over reliance where the junior lawyer treats the output as the finished product. All right. You need to make sure that any advice, court filings, client facing stuff, anything like that is not issued without competent human review. We actually make this at Spencer West a sackable offense and a termination of contract offense. All right. That is our stick if they do it wrong. So there's a false confidence where the AI tends to present things quite persuasively, but it can give you the wrong law. It can invent facts. And I've seen false citations all the time. All right. I get subject access request letters written by AI tools, and they have the wrong cases in them. All right. And the wrong law, and it doesn't actually exist. When you're looking at your AI, look at any bias or unfairness. Is it like, if it's a one you're using for hiring, does it have any kind of automated triaging or scoring? All right. Does it create personal data errors? If it's an agentic AI, as opposed to a generative AI, is it creating its own inferences about the data? All right. And like I said, an over reliance. But you have to have a big enough stick so that people will not use the output without actually going through and making sure that the output is legally correct. And the other thing I was going to touch on is what's called shadow AI. And this comes back to your culture. Are people using this kind of AI in a sneaky squirrel movement where they're not telling you that they're actually using it? So you cannot have a blanket AI ban because that just shifts it outside of your control. All right. The actual governance and control of it brings it into your control. So people will use it because it's there. Right. But it's risky because you have no idea what's happening to the client data, and the firm is the controller. So you have to implement a system where there's approved tools, clear rules, training, and supervision. So don't have a blanket no AI rule because people will not listen to that. So governance, looking at for law firms, we have at Spencer West, we have an AI committee. All right. So we have a group of people that assess this. So I sit on in terms of DPO and privacy. All right. The COPE sits on for professional duties, commitments, and supervision. We all look at the AI, the appetite for our AI risk and our strategic control. We have our AI engineer that sits on in terms of the security of the tool. And then if we get a SOC 2 report, then he's the one who goes and looks at that. And then we also discuss this with the practice group. So this is my questionnaire that comes in from the practice group going, this is what we want. This is why we want it. And these are the answers that we've got from the vendor for your questions. Just because we have so many of them, none of us on the committee have the time to go out and ask the vendor the questions on the questionnaire. So if the questionnaire comes back and it's rubbish, then I just send it back until I get the answers where we can then properly assess this AI tool. So we also look at the any kind of certifications they've got, any reports they've got, like SOC 2, the service agreement and the DPA. You do not ever look at anything without the service agreement and the data protection agreement. All right. Then we have a record of the decision, the approved tool, approved use case, like this Bloomberg's tax, no personal data, right? Any kind of data that we approve to go into it, and a review date. And we've got registers for these things. So we keep a register of the tool, like the decision making on the tool, and then the register of who's using that tool, so that we know what's going on across the firm in terms of AI use. So policies and procedures that every firm should have. Acceptable use policy. You cannot go along and deal with AI unless you have a policy that tells people what's going on, how it's going to be assessed, what's a no, what's a yes, and how to escalate things. The tool register, like I said, we've got the registers of the tool that's approved and its due diligence process, plus who's using that tool and for what purpose. You need a guidance on your prompt and output. All right, what people can put into what tool and what they have to do with the information that they get out of it. Now, this can be part of your AI use. So the output for us, like if they're putting the information and they're getting this information out, that has to go on the client file. You need the vendor onboarding checklist. This is my mammoth questionnaire that I use, and it's got far more information on it than just the transfers, sub-processors, etc. You need the incident and breach playbook. So this is if it all goes wrong, what do they need to report? Who decides what's going to happen? And how do we preserve the evidence of what went wrong? And then there's the training and supervision. Don't just kick out an all singing, all dancing AI tool without telling people how to actually use it. And it should be role specific. So from idea to output, the matter level workflow, the purpose, what are you asking it to do? The data, what's going to go in? The tool, is it approved for that data? Controls, have you done the DPIA? And the output, who verifies it? All right. Now, the workflow in using the AI has to be built in, because certain tools are good for certain purposes. Not all tools are good for all purposes, which is why you need to know what's going on with each AI tool. Client communication. So building client trust. Like I said, they don't need the technical manual, all the nuts and bolts. We say something in the privacy notice like, the firm may use approved technology, including AI supported tools, to assist with legal services, right? We don't say anything more than that. And then that reassures the client that we are responsible and we're not using uncontrolled public AI for their matter. What you don't go and rush about and tell them is any kind of matter-specific AI unless the client comes back and expressly wants that kind of information. And that will depend, obviously, on who the client is. And what to warn about, I mentioned this before, we've got this in our engagement letter now, that clients using public AI with firm advice or confidential information may risk confidentiality and privilege. But you have to use the wording that matches your actual controls. Don't overpromise and underdeliver. Right. I'm just about the end here, then I'll take some questions. So what to do if it goes wrong? These are places where it can go wrong. The wrong tool, uploading client information into a public chat box, the wrong setting. The tool has been approved, but is not configured properly. All right. And it retains information longer than it should. The wrong output. Your output mistakes a material fact or gives you the wrong information. Or the wrong recipient. The tool exposes client matter through permissions, links, or shared workspaces. You have to be able to configure your tool properly. So if it all goes wrong, your steps are contain the incident, right? Stop the rubbish, like pull, go see what's going on, stop it, contain it, preserve the logs of what went wrong, identify the data and what's going on in the tool, assess what needs to be reported, like does it go to the DPO? Do we need to tell the ICO? Brief the client team over what went wrong and document the decision in terms of reporting it to the ICO, reporting it to the SRA, reporting it to the client. And this is a quick whizzy 90-day plan, right? And your AI should not, your implementation of an AI should not be, oh yeah, let's get this done by the weekend, mates, because somebody wants it by Friday. All right. First use is the discovery. What do they want to use it for? All right. Okay. Look at your AI, investigate your AI. The next 30 days is you're approving the initial tool, you're doing the DPIA, you're looking at the vendor onboarding. Are you going to do a trial? Like we're running trials on some of the big AI platforms, see if we like them or not, right? And then the next stage is embed it, right? Train the teams, launch, you've got your tool registered, know who's using it for what purpose, monitor its use, and then refine the policies as you go. We have been, since we put out the AI policy, we have been constantly refining this. Because like one of the refinements was I actually thought that people would realize that they can't use consumer subscriptions for business purposes, but they didn't. So now that's part of our AI policy. You must use an enterprise subscription or it's game over. You're not using that one. Right. Here's your quick takeaways on this. Know the use case and the categories before approving your tool. Keep client confidential and privileged material out of any public AI. You must do a complete DPIA and vendor due diligence. Look at the contract terms. All right. Absolutely require human supervision and verification of your AI outputs, and maintain your policies, tool registers, and review dates. Don't just stuff them in a drawer and leave them there. It's a constant process of looking at the registers and the policies. Oh, any other questions? I've done that one. Anybody got any other questions? Feel free to pop them in and I can answer them now.
We've got one, Alan. If a client says they are using closed source AI, to what extent do we look to verify that, or just take their word?
Oh, is the client putting their information or like for example, my lease one? Are they putting that into it? I'm not sure what the client's doing with it.
Yes. Alan says yes.
The client's putting information into it. Okay. You don't need to see the fact that the client, the screenshots of the client putting the information in. When the partner phoned and told me that her client had uploaded her lease, he was the landlord, with all the tenants' information in it into AI, and AI suggested, she was quite ticked about this, AI suggested that she go and do blah, blah, blah with it. I told her to contact the client and warn him that he had breached confidentiality and potentially waived privilege, along with a possible data breach, and had her go and tell the client that. And that's what I would tell any client who wants to go and upload information, their legal information, into an AI tool. All right. It depends on whether you've got the skills to go and investigate what the client's done and whether you actually want to go down that rabbit hole. See, we don't want to do that. We're just putting the warning in the engagement letter of don't do this because this is what's going to happen. And then we've got the additional clause. If you go and do that and it waives confidentiality and loses privilege, we are not responsible for any loss, damages, blah, blah, blah from there. I hope you found the presentation useful. Assessing an AI platform is a very labor-intensive task. I constantly have these questionnaires come in. I look at them and think, oh, that's bloody rubbish. And then I send it back. And then the next one I get in doesn't have the service agreement or the the DPA attached. Or yes, they are SOC 2, but they don't send me the report. So there's lots of things that go on before and any kind of AI platform is approved. And then what we do is we put the approved platforms. We have an intranet, we have the list of approved platforms, and we have the list of platforms that were not approved. So the approved platform, for example, Bloomberg Tax, is yes for research, but no, you can't put client data in it. And then someone who wants to come along and use Bloomberg Tax will have to tell our AI at Spencer West email that they want to use Bloomberg Tax. And then they are signed, then they go on the AI register so we know who's using it and when they've signed up for it, and whether they buy the license or we buy the license. All right. So there's a lot of work that goes into the approval of a tool. Yes, the slides will be sent out to everybody. I hope everybody found that useful. It is a high level thing. Like I said, there's a lot of work that goes into AI, but don't just go and say no AI, because to be honest, they're not going to listen to you and they're going to run off and do it anyway. So the best thing you can do is put in the controls that safeguard the firm, the clients, all right, and the partner who actually wants to go off and use this AI tool. It's all about managing the risk and putting the mitigations into that. All right. Well, thank you, everybody. I hope you've enjoyed the presentation and found it useful. Brett will be sending slides out for everyone at the end. But if you do have any other questions which you didn't pop on to here, then please send me an email and I can help you out that way. Cool.